Welcome to NEOMENTORS EXAM360. We are going to continue on the series of classes that try to explain us how to approach the polity related MCQs or solving the MCQ questions on Indian polity. The question is, with respect to special leave petition of Supreme Court under Article 136, consider the following. So special leave petition is a power that has been vested with Supreme Court under Article 136 as per Indian Constitution. So this is a special power, as you know. The name itself suggests how Supreme Court could intervene or could meddle with any court proceeding that is going on in India. It might be High Court, it might be subordinate courts, etc. So what is this power? Let us look into the options and then let us try to eliminate them one by one. First is it can be issued to any matter passed by any court in India, including the military tribunals and court martials. So, of course, it can meddle with any ongoing proceedings happening in the country, but not with respect to the military tribunals and court martials. Why? Because military tribunals and court martials operate on special laws, special procedures, standards, etc., which cannot be confined to the Supreme Court or the judiciary in the country. The military tribunals operate on military laws, and any disciplinary action taken on the soldiers who are not complying with the standards set by the military court are tried by those tribunals itself. So, in that case, why should we vest such power to Supreme Court? Or else, if we vest such power in the Supreme Court with respect to military tribunals, there is a possibility of dilution. And military tribunals, as you know, are specialized to deal with the military matters. So why is there a need to vest such power with Supreme Court? Because already it has been vested with military tribunals. Supreme Court might not be able to understand the nitty-gritties of the issues faced by the soldiers, and thus it couldn't, or it might have difficulty to deal with the matters of military. So in this way, you could eliminate the first statement as false. So this is false. The next one is the discretionary power of the Supreme Court and can be claimed as a matter of right. Yes, it cannot be claimed as a matter of right, because if it is claimed as a matter of right, then everyone is going to go to the Supreme Court and give their own petitions, try to see that Supreme Court will intervene in that matter if it is happening in High Court or subordinate courts, etc. If that is subordinate courts, if that is allowed to happen, then of course the burden on the Supreme Court is going to be very high. So Supreme Court should use its discretion or use its own reasoning to enter into proceedings or to meddle in any proceedings and then try to forward that case, rather than allow individual citizenry of this country to try to use it as a right and try to pursue justice in this manner. So this is true. The third statement is it can be granted in any judgment, whether final or interlocutory. So this too is true. So even if the proceedings are ongoing, even if a judgment has been reached, whatever might be the status of the case, Supreme Court can look into that matter through its own discretion under Article 136. So this too is true. So this also shows why Supreme Court is supreme or is the highest court of the land. So 2 and 3 are true. So choose the correct option. The answer is B, only 2 and 3. So this is about the first question. The next is, which of the following is true regarding the concept of judicial review in the case of India? So judicial review, as the name itself suggests, it is the review by the judiciary. Reviewing means it will look into the matter. The matter might be legislative, executive, or even judiciary. Okay, it might be anything. But Supreme Court, through its adjudicatory powers, will look into that matter and try to evaluate it through the laws of land or certain principles that are enshrined in the Constitution, and then will decide whether the action taken is as per the expected standards, or whether it is legitimate or not, whether it is acceptable as per the law of the land or not. Might be constitution or any law document. So that is judicial review. So judicial review, the statements are, judicial review isn't explicitly mentioned in the constitution. No, it is false. Of course, judicial review as such is not defined and the term judicial review hasn't been used. But in many cases, judicial review is explicitly stated in the constitution. The articles 13, 32, 131, etc. are few such articles which give such power to the Supreme Court. And Supreme Court can look into any matters that are happening in the country. It might be legislative laws, executive orders, a judiciary, nothing but judgments of the judiciary, and then evaluate them under the powers vested with the Supreme Court, and then decide the merits of the matter, and then give its final order, which will be binding. And it can also review its own judgments. That is the extent of power that has been vested with the Supreme Court. That is why it is considered as conscious keeper of this country. So statement 1 is false because it has been stated explicitly. The next one is judicial review is applicable to executive orders of state governments too. Yes, it is true. Because state governments come within the country's state machinery. It has its own administration, and its matters or its decisions could have impact upon the functioning of the country, as well as it might impact the rights of the people as well. Of course, we should give power to the Supreme Court to look into that matters as well. The third statement is, in the case of US, the scope of judicial review is much narrower than that of India's case. So you could dismiss this case by watching the proceedings of the Supreme Court in United States. So the power vested in the judges of United States is far more greater than India. Judicial review is far more greater, or extent is larger. And if you look into the provisions of the constitutions under Article 21, we follow due process of law. Procedure established by law. We follow procedure established by law. Whereas American Constitution, American laws provide the judiciary with due process of law. So the power vested with the Supreme Court is far more, Supreme Court of United States is far more higher. The name given is Federal Court in the United States. So the third statement is true. So choose the correct option. The answer is only 2 and 3. Which of the following are true? Only 2 and 3. So the answer is B. The third statement given is much narrower. So this is false. So the answer is only 2. It is B. In which of the following cases, Parliament can make laws in matters enumerated in the state list? So we have seen about the state list. State list means the subject matter within which the state has been given the power to legislate, to take executive actions, etc. The state list comes under Article 246, 7th schedule. This enumerates the state list within which state has the competency to legislate, to execute, etc., etc. So there are certain special cases where even the Parliament can legislate in the state lists. Why? Because there might be some external exigencies. External exigencies. Exigencies means certain crisis periods wherein there is a requirement for the country to operate as a union rather than as a federal government, federal state. So, in those cases, we should give more power to the Parliament to see that it could take care of the matters of the states and try to sail through the crisis. So, what are those situations where Parliament has been given the power to look into the state list as well. The first one is during national emergency. Of course, during national emergency, our country becomes a unitary state, so it becomes a union. So at that point of time, we need to give special powers to the Parliament, and thus we could legislate even in the state subjects as well. First one is true. Next is during president's rule. Even during the president's rule, it becomes a unitary. That is, whatever the states on which president's rule has been imposed under Article 356, at those periods of time, state legislature or state government is not in operation. Governor or any executive appointed by the president is now in charge of that state. So obviously at that point of time we need to have a body to legislate in the state subjects, and the Parliament takes that course of legislating in the state subjects. So the second one is true. The third one is to implement international agreements, and this too is true. Implementing international agreements comes under Article 253. And during any agreement entered by the central government with any international state, it might be the government of that state or it might be any association of that particular state, if central government has entered into that agreement, it might be United Nations or WTO, etc., etc., that is intergovernmental bodies or international bodies. The central government enters into that agreement. It is with respect to the entire country, and thus to execute that agreement, we need to give special powers to the central government, because international relations are important, especially to uphold the interest of India. It might be trade areas, security related agreements, environment related, etc., etc. In those matters, special powers are given to the Parliament to legislate on that matter, and only if there is parliamentary approval, then only they can also legislate on the state lists. We cannot simply vest such power in the central government. So central government need to take permission from the Parliament through its own legislations and let it pass through the parliamentary route by having the approval of the members of the Parliament, and thus it could execute the agreement that it has entered into at the international level. So even the third one is true. So the answer is 1, 2 and 3, that is D. Next question. Consider the following statements about President's rule. So President's rule, as you know, it could be imposed upon the states under Article 356. Let us read the first statement. According to Article 356, President should act on the report of the Governor and not otherwise for imposing President's rule in a state. Now here you could dismiss it by simply using the reason. Why should we vest so much of power in the hands of the Governor? Why shouldn't President also, through the use of conscience as well as sound decision, react upon whether we need to impose emergency on the state or not? For example, if the President has received a report that there is a disturbance in that particular state, or the state is planning to not act as per the decisions taken by the center, then obviously President should have such power. Of course, it is always the case that the Governor is going to give the picture of the state to the President, and President acts upon the way in which the report has been presented to the President by the Governor. But of course, there might arise a situation where Governor is not acting fairly, or he is biased and he is not sending the report accurately, and at that point of time it is duty bound or it is necessary that the President act as per the knowledge that he received about that particular state. So obviously the first statement is false, and you can also use the reasoning to eliminate that option. Next, Article 355 imposes a duty on center to ensure that the government in each state is carried on in accordance with the provisions of the Constitution. So this can be judged as true. Why? Because if the states do not follow the provisions of the Constitution, then the entire constitutional machinery is going to go in a breakdown state, at that point of time, we require the central government to step in and try to repair whatever the damage that the state has done, and thus impose president's rule on that state under Article 356. So this one is true. Next is a proclamation imposing president rule must be approved by both houses of the parliament within 2 months from the date of issue. This too is true. Because we cannot simply vest the entire power to take decision on imposition of president's rule to the central government. If we do that task, then obviously central government might have a political vested interest to impose emergency to take control of that state by either dissolving the state legislative assembly or simply seeking a route through which the political party members who form the majority in the central government come to power in that particular state. So obviously central government should seek permission from the parliament as well. Parliament should give its approval to the decisions taken by the central government. Then only the state emergency could be imposed. The other thing also is that when central government controls the parliament in its entirety, then there are chances that parliament may take the decision taken by the central government. So at that point of time, we also have an option to go to the judiciary, that is Supreme Court, and intervene in this matter. Thus, using the judicial review, Supreme Court could give its decision on the basis of the merits of the case. Okay, so this too is true. Now, the options that are 2 are 2, 3. So the answer is C, 2 and 3. Next, consider the following regarding the amendment of the Constitution. Amendment, as you know, that you are trying to modify an article, or you are trying to add an additional article, or you are trying to make few changes which might not be of that important consequence. But there are certain articles which need to be upheld and which also require the consent from the states as well to make changes in that article. Okay. So the power to amend the Constitution is under Article 356. Sorry, 368. 356 is regarding emergency. So Article 368 is about the amendment. Let us read the first statement. An amendment to the Constitution can be initiated in the state legislatures. You might be confused reading this particular statement because we have said that India is a federal state, that is, power is shared between the center and the state. But if you look into the articles of Indian Constitution, we have Article 1, which states that India is a union of states. And if you look into various articles, it gives priority to the union rather than its units. So union is more powerful than the units. This is to see that integrity and unity is maintained in this country. At those points of time, we also require allocating more power to the central level legislature or executive so that the unity is maintained. If we give more power to the states to amend the Constitution, obviously states might again and again request for amendment so that their interests are protected. But at the central level, the union tries to see that there is unity, and thus it will try to take decisions that are good for the entire country rather than for particular states' vested interests. So that is why in India we didn't give power to the states to initiate the procedure for constitutional amendment. So in this way you could eliminate the first option. So states cannot initiate, that is, state legislature cannot initiate the procedure for amending the Constitution. So this is false. First statement is false. The next one, the bill cannot be introduced by a private member. This is false. Why shouldn't the private member of the parliament or legislature at the center not be given power to amend the Constitution? Because that is not any irrational or illogical thing. If there is any wrong or if there is any requirement of changes in the provisions of the Constitution, then anyone could step forward and give a representation to the parliament to do certain amendments in the Constitution. He might be private member or he might be the government or minister of the government. So that is why we can also vest that power in the private member of the parliament. So this is false, right? Because after all, he is a representative of India, that too at the central level, and thus he too has the power to initiate the procedure for constitutional amendment. But most of the times they are a failure, right? Because he has to get the approval of the houses. He is a private member. He might not have that amount of power to influence the parliament to take decisions as per the decisions or as per the procedures that he thinks are good for the rest of the country. Because amendment of the constitution after all is a big task. It needs to get the approval of majority of the houses. So it might not happen most of the time. The third one is such a bill requires prior permission of the president. This too is false, right? Because constitutional amendment, as you know, is an important task, and that should not be simply vested in the hands of president. President is a nominal post, as you know. The post is symbolic, and by looking into the significance of the matter, the parliament hasn't vested such power in the president. Of course, earlier president may act on the constitutional amendment or may not act on the constitutional amendment. So prior permission of the president is not required to pass constitutional amendment act bill. The other thing is that president has to compulsorily give his approval to the constitutional amendment act constitutional amendment bill passed by parliament. Okay, then only it becomes act. But he has to compulsorily give his assent to the constitutional amendment bill passed by the parliament. This under 1971 amendment, 1971 24th Constitutional Amendment Act. This has made it compulsory for the president to give his assent. Prior permission means before initiating the proceedings in the House with respect to passage of constitutional amendment bill, the permission of president is a necessity. But here it is not a necessity. We need not ask the permission from the president to initiate the proceedings for the discussions on the constitutional amendment bill in the parliament. So obviously the third statement is false. The fourth one, the bill must be passed in each house by a special majority. That is majority that is more than 50% of the total members of the house, majority of 2/3 of the members of the house present and voting. This is true. This is a case of special majority. Even if you look at the numbers like 50% or more present and 2/3 of them voting is a substantial number. That also gives us the importance of the constitutional amendment. That amount of power should be vested in more numbers rather than less numbers. So in this way you could also guess that this is true. So only the fourth statement is true. The answer is C, only 4. Next, sixth. Consider the following regarding the amendment of the constitution. The president must give his assent to the amendment bill. He can neither withhold his assent to the bill nor return the bill for reconsideration. This is true. So we have already seen in the previous article that 24th Constitutional Amendment Act has made it compulsory or had made it binding upon the president to give his assent on the constitutional amendment bill passed by the parliament. This is passed in the year 1971 and thus the changes have been invoked in the articles of the constitution. Next is each house must pass the bill separately. Yes, this too is true, right? You can also guess this one. Why? Because if two houses can sit together and pass, obviously the ruling party at the center will have a majority say, right? Why? Because the numbers of the Lok Sabha are greater than the Rajya Sabha members. Then if you give more power to the Lok Sabha by allowing them to pass the constitutional amendment bill through a joint session, then obviously it will impact the outcome of the parliamentary proceedings. So obviously to negate the numbers of the Lok Sabha, we need the constitutional amendment bill to be passed separately by the Lok Sabha and the Rajya Sabha. So in this way, we could protect or see that the provisions enshrined in the constitution are upheld and the sanctity of it is restored, rather than vesting such power in the hands of the ruling party at the center and bring changes that might actually impact the characteristics of the constitution. So, in the case of disagreement between the two houses, there is no provision for holding a joint sitting. This is true. Okay. So, the first statement must give his assent. This is true, and the second statement is true. So, both are true. The correct answer is C, both. Next, the provisions which are related to the federal structure can be amended by a special majority of the parliament and also with the consent of half the states' legislatures. So, this we have already seen. Next, the question is, which of the following is not one such? So, which of the following doesn't fall within the jurisdiction where we also need to seek the approval from half the state legislatures? That is the question. So, let us look into the matters where we need not seek the permission from the state legislatures to get the constitution amended. First one is A, any of the list in the 7th schedule. This is true. So, 7th schedule has enumerated state list, central list and concurrent list, right. So, this decides the jurisdictions of those respective state legislatures as well as executives at the center and state level. So, obviously, we are also making decisions upon the extent of jurisdiction of the states and center as well as the concurrent list where both center and state has the power to legislate or to take decisions and pass executive orders. That is why in those cases state should be given power and thus state have been given power. So, states assent is required for making changes in the constitution. Next, B, the power of parliament to amend the constitution and its procedure. So, if we change the article 368 itself, it also impacts state's power. So, obviously, changing the constitution is a power that ultimately impacts the ability of the states to operate as per the expectable standards to deliver the right way of doing administration at the state and central level. So, obviously, this power should also be vested in the hands of states as well. Next is election of the president and its manner. See, election of the president, as you know, even the state legislatures are party to it. So, if they are party to it, if they too participate in the elections, the two indirect elections for appointing president, then obviously state should have a say, because the interest of the state should also be represented at the center. Though the president is more inclined, or the office of president is more directed towards conducting the office, conducting transaction of business at the central level, so that the administration at the central level happens smoothly, because administration matters or legislative matters or executive orders are done on the name of the president. Ultimately, president's assent or president's signature is a necessity. But electing is altogether a different matter. In those cases, state legislature has a say beyond this election of the president. On the other matters, the state doesn't have any say. Next, the fourth option, abolition or creation of legislative councils in states. Okay. So, legislative councils, as you know, is not an important body. All the state legislatures do not have legislative councils within them or among them. So, that is not important in the constitutional scheme. If that is not that important, obviously, there is no requirement of the states to decide upon establishing legislative councils within the states. If that is the case, this is false as per the given requirements. Though it is true, abolition or creation of legislative councils require the role of parliament, but it is not strictly speaking a constitutional amendment where state has a say. As per the constitutional amendment procedure. Of course, state legislature has a say on establishing or on constituting legislative councils in the states, but it doesn't come under Article 368 Constitutional Amendment. So the answer is D. Next, India has adopted bicameral legislature, wherein the Rajya Sabha forms the upper house and the Lok Sabha forms the lower house. Consider the following with regard to Rajya Sabha. So bicameral, as you know, two houses. It is the central legislature is divided into two houses. Of course, president is an integral part of the central legislature or parliament. Along with president, we have two houses, Rajya Sabha and Lok Sabha. They together constitute the parliament, and parliament conducts business as per their respective representations and the powers enumerated in the constitution. Okay. Now consider the following regarding the Rajya Sabha. First one, the number of members to be elected from each state has been fixated by second schedule of the constitution. So of course there is an article which enumerates the number of members to be represented from each state, but that is not second schedule, that is fourth schedule. So obviously the first one is false. So this you need to have prior knowledge. Reasoning in itself will not be sufficient. Why? Because there are articles in the constitution which mention the number of members to be represented from each state in the Rajya Sabha, but you should remember that it is fourth schedule. Next, it is an indirectly elected body. Of course, it is an indirectly elected body. Why? Because we as individuals of the citizenry who have the right to vote do not have a say upon the members to be represented from our state. Ultimately, the elected legislative members of the state have the power to elect the members to represent them from the state in the parliament. So if that is the case, this is nothing but indirectly elected body. It is not a directly elected body. If I, as a citizen having voting rights, have a say on the matter of the members to be represented in the Rajya Sabha from my state, then that is called direct election. But he is indirectly elected by the directly elected members of those respective states who are trying to send members from that state to the Rajya Sabha. So this is true. Next is, members of the Rajya Sabha are elected for a term of 6 years and they are also eligible for re-election. This is true. So you have to remember that the tenure of the Rajya Sabha is 6 years, and the other specialty is Rajya Sabha is not dissolved, or it cannot be dissolved. It is a continuous house, and 6 years is nothing but the time period an individual can be represented in the Rajya Sabha from that particular state. The tenure is 6 years, and that is why Rajya Sabha is never dissolved. It is a continuous body, permanent body. Why? Because every 2 years, 1/3 of the members are again elected by the respective states, and then they send those members to the Rajya Sabha to represent a particular state. So this too is true. Now, which of the above statement is or are correct? Second one is true, third one is true, and fourth one is true. Only the first statement is false. So the answer is 2, 3 and 4, B. Next, with respect to the merits of the parliament form of government, consider the following. Merits. So what are the merits of the parliamentary form of government? We as Indians have adopted parliamentary form of government. The first statement is harmony between legislature and executive. Obviously, this is an advantage of parliamentary form of government. Why? Because executive is a part of the legislature as well. That is, Prime Minister or the Council of Ministers, which is headed by the Prime Minister, are all elected from the legislature. So they sit in the proceedings of legislature as well. They take decisions on the laws as well as they take decisions on executive matters. So there is harmony between the legislature and executive. Next is the responsible government. Yes, it is a responsible government. Why? Because if it loses the majority approval in the house, that is, it is losing the will of the people, and thus they can no longer form the government if they do not have numbers in the legislatures. So in this way, it is a responsible government. At the same time, the proceedings of the legislature are watched throughout the country, and then people make opinions on it, and thus they will elect candidates based upon the credentials. Next is wide representation. Yes, it has wider representation, especially at the executive level, because they should try to represent the interests of various sections within the country. As you know, we have various sections. It might be caste, class, religion, regions, etc. Then only it will have a say, or it will have the possibility, to get themselves elected in the next election, or else people will lose hope or lose trust upon that government and thus vote it out of the power. And as you know, the Council of Ministers, it could be to the tune of 15% of the total strength of the legislature. If that is the case, then obviously you can bring more members into the cabinet, more members into the Council of Ministers, and thus choose from different sections and thus give more power to the diverse sections of the society and make them feel inclusive. Next is, it prevents despotism. This too is true. Why? Because if you look at the representation, Council of Ministers, number of ministers who are nothing but the elected representatives, and they can take decisions on the behalf of the people, thus we can stop despotism. If only one individual has been vested with so much of power like the President of the United States, then there is possibility of accumulating huge amount of power and misuse it, the possibility of tyranny of individual. That is not the case in India because of the parliamentary system. Next, there is no continuity of policies. Of course, this is one of the issues faced by the parliament, parliamentary form of government. The possibility of different parties coming to power, the elections happening again and again, and the Council of Ministers who form from different sections, or who could also be from multiple parties because of the coalition form of government that is observed in the parliamentary form, especially in India. If that is the case, there is a possibility that the government that is going to be formed by different political parties in the next election might not be favorable to the policies passed by or policies executed by the past governments. Then the continuity is lost. If the continuity is lost, then a vision that has been set by the previous envisioned or visionaries of the political parties will be lost, and thus possibly we will not be able to accumulate the fruits of their endeavors. For example, it might be economy, it might be politics, it might be international relations. They might have set particular standards. For example, trying to represent the interests of India in trade related matters. The newly formed political party or newly elected political party might have different opinion, and thus might lose track of the important matters dealt by the past government. But this is a demerit. But we are talking about the merits, right? So the important merits are 1, 2, 3, 4. The answer is C. 10th one. Which one of the following couldn't be termed as a demerit of the parliamentary system? So, which cannot be considered as a demerit? Dictatorship of the cabinet. Actually, this is a demerit. Unstable government. This is a demerit, especially in the parliamentary form of government. Why? Because there are periodic elections and multiple parties, coalitions, etc. We might not be able to form stable governments. The third one, or C option, is against the doctrine of separation of power. Yes, this is a problem because legislature and executive are harmoniously functioning. Though harmonious function is a merit, but there is duality in membership. There might be a possibility of conflict of interest if an individual is part of both executive and legislature. That is why we have a doctrine of separation of power, to see that both operate independent of each other, so that there is no conflict of interest, so that power is not vested within few hands. Because here your executive is having the power to legislate as well, right? So at that point of time, executive might be inclined towards framing legislations that actually empower executive more. Thus, power of the executive might increase. This might lead to concentration of power in the executive rather than making executive accountable to the legislature. After all, the duty of legislature is not only to pass legislations but also see that executive is responsible to the people, and it is done through various instruments of the legislature. So in this way, this is a demerit. Wide representation is a merit. We already seen how wider representation is important to not only reduce the possibility of concentration of power, but also to give representation to wider sections of Indian society. So the answer is D. This completes the class. Thank you.